We have enough material to find out the evidence is flowing and it's enough.
We will also tell you why the judges warned Chachuchikata to mind his language.
This is Top Story with Evans Mensah.
Top Story is brought to you by Bond Financial Services, your success are passion, Belacra Mineral Water, the new generation mineral water. It's also brought to you by Lifebuoy, still 100% better germ protection. Also by Blue Rose Limited, Shelter for All and Star Life Assurance. The National Democratic Congress today suffered a setback at the Supreme Court when its application to cross-examine additional witnesses in election petition hearing was dismissed. The party's lawyer, Chachuchikata, was later warned to mind his language by Justice Akoto Banfo, who questioned his temperament. Now, Mr. Chikata had used the word retrograde to describe an objection raised by the petitioners. We will hear more about that in a moment. But first, to the substantive issue of the NDC's attempt to interrogate additional witnesses who had sworn affidavits supporting the case of the petitioners. These were the arguments for and against that motion.
We are submitting that under the provisions in section 62 of the evidence decree, these witnesses being available, we ought to be allowed to cross-examine them, and it's clearly in the interest of fairness and of justice in these proceedings that they be cross-examined.
We are opposed to this application with regard to the application to cross-examine Kwabnachu Mnyama, Eugene Saki, Frida Pempe, and Peter Wuni. In other words, my lords, we are not opposed to the cross-examination of Abdullah Abdul Hamid and Hussein Safiano. CI 74, Rule 69C4 states that the court shall inquire into and determine the petition expeditiously and shall give its decision not later than 15 days from the close of hearing. As they deem to have admitted those depositions, they have not filed any supplementary affidavit to challenge them. And therefore we respectfully pray that this application be dismissed.
And I respectfully submit that CI 74 and its provisions on expedition do not set aside, as your lordships have said many times, do not set aside the rules of evidence and the procedures of this court. The issue of delay was one that he said justified your application of CI 74, and that's what I'm responding to. And I'm saying that it's disingenuous because he admits that in relation to at least two of the witnesses, his argument about expedition does not apply. So he cannot pick and choose for this court.
The judges took a long break to consider the arguments. They returned with a verdict dismissing the NDC's motion.
Action involved in the cross-examination of the witnesses covered in these applications. In the circumstances, the applications are refused.
My lords, we agree.
As the court pleases, my lord, may we seek some clarification? Does that mean that even those that they do not oppose?
They are all covered. We are saying that we have enough material to find out the evidence is flowing and it's enough. We don't need to protract things. So that's what we are saying.
As your lordship please.
Yes, we don't need all those things.
Now, let's dissect the ruling we just had. I'm joined now by Samson Ladagen, a lawyer and journalist. Thank you, Samson. Now, Samson, break that ruling down for me. In plain language, what were the judges saying in response to Mr. Chikata's motion there?
All right, just Tuguba's ruling is simple. Evans, they are saying that we don't need any further evidence. We have sufficient enough to be able to get to the truth. Interestingly, you see that their lawyers refused the application, even though the petitioners in their opposition indicated the application by the respondents in part could be entertained, only that a part of it had been overtaken by events, i.e. to say that it's been rendered obtuse or needless because of certain admissions about the annulments of the particular votes or the case of voting without biometric verification, which they said had made the issues no longer matters in controversy, and therefore there's nothing to prove. The respondents, I think, Evans, may have satisfied the requirement of showing compelling reason to warrant the calling of at least the other two witnesses for cross-examination. But what ought to be noted, and briefly, is that this is a discretionary relief that they were seeking at this trial. And the court, largely on the overriding consideration of undue delay, waste of time, or needless presentation of cumulative evidence as provided in, they are empowered by Section 52 of the Evidence Act, even to exclude such evidences if they find that it will simply delay the process or waste their time. So they are saying, and you heard just that Tuga say, more importantly, Evans, that they have sufficient evidence so far by way of their pleadings, by way of the affidavits and the testimonies that are going on. So they don't need any more, so they should just forget it.
Thank you very much, Sam Singh. Joining me in the studio now is member of the NDC legal team, Victor Kojoga Dawudu. Also joining me right now is member of the MPP legal team, Yabo Abinasama. Thank you very much, gentlemen. I want to start with you, Mr. Dawudu. Disappointed?
No, we are never disappointed. I don't think it's a setback. What we were looking for is that there is evidence, as the court has put it, that we are obliged. The court says that there is enough evidence by the pleadings, by the affidavits that have been put before it, and it will be immaterial to ask that the people we wanted them to come and testify, to verify, to ascertain the truth of the matter, that it is needless. So that's what the court has said. Secondly,
you agree with that, though?
Oh, I think largely, and the petitioners were even saying that some of their people could be cross-examined, like Abdullah Hamid and Husseini Safiano.
But isn't that a surprise? Although they said that, they made that concession. The judges in ruling said, we are not entertaining any.
Yeah, it's just go to reinforce that, yes, in part they have agreed that some people the witness should be put in the witness box. So it tells you that our thinking and their thinking on that score, we agree. And the judges think that no, we have enough evidence. What it's before us, we can make a determination of this whole case without these witnesses.
Was this expected?
That the
ruling will go the way it went?
Largely, I think yes, because you have to have a compelling reason. That is the only basis that the court, in setting up the mode of trial, gave, that there has to be compelling reason. Now, in this case, where was the compelling reason? The compelling reason had been overtaken by events emanating from the second respondent, who, in truth, is the only one who, at this stage, can be taken for an authoritative voice on some of these matters, because they have the statutory authority to do the things that were said to have been done in the affidavits. In essence, somebody comes up and swears that I saw this thing done by the Electoral Commission. And then the Electoral Commission comes and says, yes, it was done by my people. And then you say, I want to cross-examine the man who alleged that and find out if he's truthful. So the court assumed that going to this process, when the proof had been offered by the authority better placed to offer that proof, would not make.
But Mr. Dawudu, clearly from the arguments we heard from Tashin Shikata, you believe strongly that if you had those witnesses in the witness box, it would have helped your case.
Well, no, it would have helped the court to ascertain the truth.
The court says we don't need it.
Yeah. You see, even Dr. Baumia, in his earlier testimony under cross-examination, a question was posed in relation with Honorable Frida Prempe about being annulled, the results being annulled. And he said that the best person who could answer that question is Honorable Frida Prempeh. So there is a clear admission that he cannot speak to what Frida Prempeh has deposed to.
That was yesterday.
Yeah, that was yesterday. So it's a confirmation that yes, there might be the need for Honorable Frida Prempeh and others to come. But the court just said simply that, look, we have a lot of evidence. If they don't even come, it is insignificant. We can go ahead. Secondly, the EC making some admissions that yes, some of their officers.
The EC disputed that though.
No, yes, what they disputed.
Even Chachu disputed that they've made admissions.
No, Chachu said that what the EC has said has nothing to do with the first and the third respondent. Now, let me come to the EC. The EC said yes, they have made some admission. That admission they've made is that the regional officers or the regional directors were not aware of those annulments. So it was the polling station officers and the returning officers. They took that decision. So whether the decision was right or wrong was not communicated to the regional directors and the headquarters. So if they were to come, the court would have known whether that discretion that was exercised by the the presiding officer there, whether it was right or not. But as the court has said, I'm sure they will make pronouncement on those, as they said they have evidence.
So, I mean, you agree with that?
No, I don't. You see, Victor, because the EC hasn't deposed to a situation where it disowns its officers, that they acted wrongly. They are saying that regional officers were not informed. Yeah. They are not saying that those officers did not have the power to do what they did. That's different. So if they had come and deposed and said those officers acted illegally and ought to have sought permission before acting, then you have a case in dispute. But when they merely say that we're not informed, it does not go to the fact that it has been done by the EC, because those officers represent the EC at that level.
I see.
And they take decisions on behalf of the EC at that level. And their decisions impact the election.
I see you nodding. You agree with that?
Yeah, I think we are on the same page. We are on the same page. If they have annulled, they took that decision. Was that decision taken rightly or wrongly? And I'm saying that that would be one of the issues that the court may look at. Whether EC at that time or the presiding officers or returning officers could or had the power or they had the legal backing to annul the result. Yes. It will be one of the issues that would come up.
But the EC hasn't deposed to that. They haven't said that there was no power. They have actually filed an affidavit in opposition, or rather an affidavit denying, like challenging that, yeah. But that challenge is not based on a lack of power. That challenge merely says we're not informed.
Okay. Now, having settled that, I want us to, I'll play a clip and I'll get your reaction to that. This is a clip that happened today, an exchange between Chachu Chikata and Justice Akoto Banfo today at the hearing. Watch this.
My lords, we will first tender the list in reference to Exhibit 32, which he has confirmed.
My lords, we are objecting to the tendering of this list.
It incorporates the information provided in respect of the counterpart serial numbers and the additional information regarding the duplication. It provides that. And the witness has already confirmed all the information on that list. And my lords, this is no time to just be retrograde in the way that we proceed in respect of the
Counsel, I think you must. I don't know whether you are getting angry.
No, my lords, I cannot be angry.
So please mind your language. That's all that I
Yes. Let's avoid presumptuous language. I would like to say that I believe a word I used, retrograde, was not appropriate. It was, I intended to express a point which I did not come across, and I would withdraw that word.
So, what do you make of that?
It's been a very high-strung, nervous trial. This is a trial sui generis. It's a very special case. The procedures are hopping between CI 74, CI 47, CI 16, evidence decree, and all that. And sometimes you find that the court has a problem managing the tensions and the feelings. But these are very passionate people before the court. It's not a small matter in issue. It's about the central power and authority of the state. Language has been an issue. Language has really been an issue. But when the language is directed at counsel and the witness or at each other, it's at a more, shall we say, acceptable level in terms of control. But when the language is directed at the court, then you may have a problem. And I think in this instance, he was directly addressing the
Like
court.
you had a problem yesterday when your counsel was asked to sit down.
Yes.
What do you make of what you just heard?
I think that as Mr. Chachichikata has explained,
withdrawn.
that the word that he was using or what he said was actually to the objection that the lead counsel for petitioners was, yes, because the court has asked that we do the bulk haulage approach, that's 50-50 in lots. Now, what he was objecting to, then that will mean that we'll have to go by taking it one by one, single pink sheet. So he was using the word retrograding, that will be going backwards to that system where we have to pick it one by one. But I think the court felt that he was addressing
them. Because we've had to use similar words in the past.
But
shut up, questioning somebody's experience. So the judges seem to have seen a certain trend, so they don't want him to go there.
I think that the judges have, on zillions occasions, said that we should be impersonal, we should be professional, and I think we are all learning, we are taking clue from the bench. Because you see the emotions, when it comes to election has become a lethal weapon. Now its emotions are high, and every time we are learning. I think he did the honorable thing to withdraw and said that if I've been misconstrued, I'm not angry. And I think language has become part of this. And well, as we lawyers, when we are back from there, we come to the bar, we laugh and we shake hands, and I don't think that it is time for us to go into and say, oh, this man insulted this. At the height of the tension, people may slip and say something.
Mr. W, thank you very much. Thank you very much, Yaba Miasuma, for your time here on Top Story. That's it for Top Story. My name is Evan Spencer.
Yeah.